Are you a business owner who's fallen on tough times because of COVID-19 and you can no longer fulfill your contractual obligations? Is there a legal way out of your contract? We're talking force majeure right here on Money Moves JA, brought to you in partnership with Exim Bank's Business Advisory Service. I'm Kalila Reynolds, and I've got attorney at law Mathhew Hograth. He's managing partner at MH & Co. Attorneys at Law to break it all down. All right. Hi, Mathhew. Great to have you on again, this time in a virtual setting, a virtual forum. So tell me, and I'm not even sure if I'm saying this right, what is force majeure?
You said it right. It's a French phrase, which literally means superior force. And it refers to circumstances in which the obligations of one or more party under a contract are incapable of being performed. So it's not a concept that exists generally in law. It would have to be a clause that's specifically set out and defined in a contract. And you would have to determine basically if the circumstances fit within the force majeure clause. If they do fit within that clause, then the party who is so affected and is unable to perform their obligations under the contract would be either able to cancel the contract ultimately, or they may be given some more time to perform their obligations. So you do need to look at how the specific force majeure clause is worded. So some force majeure clauses they typically give the exact circumstances under which you could claim that you are unable to perform your obligation. So it could be, for example, a hurricane. If you are a manufacturer and you have an obligation to manufacture a certain amount of goods for a customer, if a hurricane comes and disrupts the manufacturing the process, then you may be excused from performing your obligation to manufacture those goods for a certain amount of time until you have rectified the situation. You would see words like acts of God, which basically would be acts of nature. In the context of COVID, it's been highly debated, is it an act of God? Some people think it is not an act of God, an act of man.
Oh
Right?
boy, that's
Yes.
quite but does it really make a difference if it's a man-made virus or not?
Well, some are arguing that if man made it, then that excludes an act of God. So there's no, I don't think that the debate has gone anywhere with any specific conclusion.
But that
But
would be
in some,
if the clause specifically has that wording act of God, because do all of
correct.
them have that specific wording?
Most of them tend to, and where some of them just recently, I was reading a contract and it was speaking about pandemics, which is something I don't usually see in a force majeure clause. So it could specifically refer to a pandemic or an epidemic, or some of them have a catch-all that says, or any other circumstance or occurrence that may prevent one party from performing their obligations. If you do have that catch-all, I think we all agree as lawyers that an epidemic or a pandemic such as COVID could fit squarely within that catch-all.
That's
But
very wide, though. That's a very broad catch-all. Like you almost feel like you can tack anything into that.
and that is why it's important that your force majeure clause is properly drafted to have a catch-all. It really should, because none of us, I mean, the last time we had a pandemic or an epidemic was what, like 1920. So it's not something that we typically expect or in this jurisdiction here. We typically think of a hurricane, sometimes an earthquake, more often these days. But we certainly don't think in the forefront of our mind of uh, COVID.
Hmm. I think now we're going to start thinking about something like a pandemic. Now that it's hit the world, it's going to become a reality going forward. And
Absolutely.
people are gonna make sure that they put that in their clauses in the future.
Absolutely. So it's definitely going to change the way we draft our contracts now. And if it they I'm sure everyone know is I certainly am I'm including pandemics, epidemics, and I usually have a catch-all in my clauses as well. Um, but what people need to appreciate is that it's not just the occurrence of the event that may excuse the party from performing. You have to show that it is the direct cause of your inability to perform. So if
Mm,
there's an intervening cause or other causes that may be at play, then that may dilute one's argument in relation to the fact that it's COVID that has caused me to not be able to perform. Secondly, you need to prove that you have tried to mitigate, do all that you can to mitigate in the circumstances so that you can perform still. And you need to show as well that this was something that was not foreseeable. Now, I think we can all agree that COVID-19 was not a foreseeable event for most, if not all of us. Um, so if you can make that out, then you should be able to rely on the clause. If you don't have a force majeure clause, like in your contract, then you have to go back to general common law principles of the frustration of contract, which may be a bit harder to prove.
hmm. And in this day and age, I think that that catch-all clause is important because as COVID has demonstrated, there may be things that we might not even consider right now. What if, for example, there's a major data breach that affects the entire world? Because as we've seen with COVID, it's a different type of virus, a computer virus, virus that affects human beings. There's a reason both of them have the same name, but there are things, the point I'm making is there are things that one might not even be able to fathom right now because of the way the world works now and the way things have changed over the years.
Mhm. I completely agree, and even in relation to viruses, I understand that there are a number of viruses that could be coming behind this one,
Hmm.
based on the state of the world and the environment that could affect us, but we can't foresee which, if any, of those viruses may or could affect us.
Hmm. But you made an important point earlier as well, though, Matthew. You were pointing out how it had to do with being able to prove that the force majeure, that the event is actually the cause of you not being able to deliver on your contract. So don't we run the risk of people trying to hide behind COVID, for example, when
Absolutely.
really something else was going on? How do you protect against that?
Well, in law, the person who would be asserting relief under a force majeure clause would have to prove that, one, that it is COVID-19 that is the direct and cause of the reason for non-performance of their obligations. Secondly, they have to prove that, look, there's nothing in my power that I can do to work my way around this. So notice the word that I use is impossibility and not impracticability and not impracticability. So if I had an obligation to supply some services to you, but it's not impossible for me to do it, but a little impractical, it may cost me a little more.
Hmm.
That's not an excuse under law, that I
Oh.
could use. Impracticability, impracticability is not, it would not meet the test. It would mean that I just simply am absolutely unable to perform my obligations.
But if it's going
So
to cost me more to carry out the thing, let's say we had negotiated on a price in the contract, which is what contracts are for. But
yeah,
because of this intervening circumstance, COVID-19 has caused this thing, I cannot deliver it at the same price now. Can I, do I still have the obligation to meet the contractually agreed price, or can I go back now using this reason and change the price?
If your customer were to insist if you had agreed a fixed price and the customer were to insist on performance, they should not be concerned with the fact that your costs have increased. If you had a clause in the contract which allowed you some flexibility to amend your pricing, then you would be saved by that. Barring that, the supplier will be well advised to approach their customers and renegotiate the pricing. But the short answer is, if Mathhew is obligated to render a service to Kalila for $5 a month, and it's I've already done my costing, if I can still do it and perform, but it's going to cost me more, but the price is fixed in the contract, you can insist that I perform, even though my margins may have shrunk.
So for the most part, then you're going to have to be relying on a gentleman's agreement between the parties, then, Mathhew.
Or you would have to be relying on the relationship, to renegotiate terms.
Mm-hmm.
One common occurrence that we've been seeing is with commercial leases. A number of businesses have been, although they're able to pay, cash is king and paramount now. So a lot of them have approached their landlords to ask them for some forbearance for a short while. A number of landlords have looked upon such requests with favor, because they would prefer to ensure that their tenants can perform in the long term. So a number of contracts and renegotiations of terms of contracts have been taking place.
Have you noticed it going on in any other areas? The leases you said are common. Have you noticed other contractual arrangements, people seeking out their lawyers, trying to say because of COVID-19, this and that and that?
Yeah, so certainly with many parties, many borrowers, pursuant to bonds or commercial loans, have certainly renegotiated their positions. Many of them have asked for a moratorium on payments of principal and or interest for 3 months, 6 months, just to give them some fiscal breathing space until things turn.
Yeah, well, thanks for clarifying that for me, Mathhew. Clearly, this is some legal issues have come up. So many issues have come up because of COVID-19, and people need to make sure that you go through your contracts and modify them for future if you can. Can you modify it if it's already done? Would you renegotiate? How does that work?
Absolutely. I mean, as long as all parties to the agreement agree to an amendment, then that's certainly possible. And a, a good point to raise at this time is that any contracts being entered into now, the whole concept of a pandemic or an epidemic being unforeseeable has now changed.
Mm-hmm.
If you entered into the contract before the pandemic, then you could easily rely on the fact and meet the test that this wasn't foreseeable. But if you're entering into a contract now, you'd understand that there's been a shift in that one could hardly claim that it's entirely could not claim that it is entirely unforeseeable that we could have a pandemic or an epidemic. So
Mm-hmm.
the way that force majeure clauses are going to be drafted from henceforth, and the way that they will be interpreted and the test applied to them may very well change.
Yeah, that's so true. Because no, it's foreseeable. Now that it's happened, we know that it could happen again. Thanks again,
Exactly.
Mathhew, for clearing that up. All the best. That's it for this episode of Money Moves JA, brought to you in partnership with Exim Bank's Business Advisory Service. Check out their website, eximbankja.com, and follow them on Twitter and Instagram at eximbankja. If this information has helped you in any way today, please spread the news and share with a friend. Also, like this video so that YouTube shows it to more people. Subscribe to this channel and turn on those post notifications. I'm Kalila Reynolds. Stay safe.